आज आसिबो धारा 370 राय जम्मू काश्मीर धारा 370 उच्छेद प्रतिवाद रे होइथिबा मामला रे शुनानी आरंभ होइछि। 2019 रे धारा 370 उच्छेद विरोध रे दाखल होइथिबा विभिन्न आवेदन उपरे सर्वोच्च कोर्ट राय प्रदान करिवे। सीजीआई जस्टिस डीवाई चंद्रचूड़ अध्यक्षतार 5 जणिया खंडपीठ मामलार शुनानी आरंभ करिसेंति। गत अगस्ट मासरे सुप्रीमकोर्ट मामलार माराथन शुनानी करथिले। प्रधान विचारपति डीवाई चंद्रचूड़, जस्टिस संजय किसान कौल, जस्टिस संजीव खन्ना, जस्टिस बीआर गोगोई और जस्टिस सूर्यकांत को नहीं गठित 5 जणिया संविधान बेंच 16 दिन धरी समस्त पक्षों जुक्ति शुणिबा परे सेप्टेम्बर 5 तारिख रे राय संरक्षित रखिथिले।
Would automatically cease to exist after a buffer period and actions done were expressly saved. However, an express repeal by the competent legislature is required for the law to cease to exist after the amendment. The repealing statute would in such case make provisions for actions taken during the subsistence of the legislation. The observations in Krishna Kumar Singh on whether the consequence of an ordinance can subsist even after the ordinance ceases to exist cannot be transposed to interpret the limits of Article 356 because an ordinance which has the effect of a law by its very nature has a limited life. The argument of the petitioners that Parliament can only assume the lawmaking powers of the legislature of the state when the proclamation under Article 356 is issued is not accepted. The purpose of Article 357 is to ensure that while exercising the powers of the legislature of the state, pursuant to a declaration under Article 356(1), Parliament, or as the case may be, the President, are not impeded by an absence of competence which would have impeded the exercise of a similar power in the absence of a proclamation under Article 356. Further, Article 357 does not contain a non-obstante provision which overrides Article 356. To interpret Article 357(1) as a restriction on Article 356(1)(b would be to read in a restriction which the plain terms of the Constitution do not provide. As held above, the exercise of power after a proclamation under Article 356 is issued is subject to judicial review, and immunity from judicial scrutiny does not attach to the exercise of constitutional powers of the legislature of the state. The court, while judicially reviewing the exercise of power, can determine if the exercise of the constitutional power of the legislature of the state by Parliament has a reasonable nexus with the object sought to be achieved by the proclamation. The next issue is whether Jammu and Kashmir retained an element of sovereignty or internal sovereignty when it joined the Union of India. We have held that the state of Jammu and Kashmir did not retain an element of sovereignty when it joined the Union of India. We have arrived at this conclusion for the following reasons. First, Paragraph 8 of the Instrument of Accession executed by Maharaja Hari Singh provided that nothing in the instrument would affect the continuance of the sovereignty of the Maharaja in and over the state. Second, on 25 November 1949, a proclamation was issued for the state of Jammu and Kashmir by Yuvraj Karan Singh. The declaration in this proclamation that the Constitution of India would not only supersede all other constitutional provisions in the state which were inconsistent with it, but also abrogate them, achieves what would have been attained by an agreement of merger. With the issuance of the proclamation, paragraph 8 of the Instrument of Accession ceased to be of legal consequence. The proclamation reflects the full and final surrender of sovereignty by Jammu and Kashmir